And of course, tonight we have with us Professor Ruth Lapidoth, who will be giving the major talk tonight about the future of the Egyptian-Israeli peace treaty, which is so appropriate because of the uncertainty we have with the regional conditions that are emerging. We know who some of the leaders are in this region, and some of them look familiar, but in 2 or 3 years, we have absolutely no idea, and yet we have international legal commitments. And how does that exactly work? Are there plans to wiggle out of those commitments, and how does the international community respond to those commitments? So I think there's nothing more appropriate that we could discuss tonight than what Professor Lapidoth is doing. And she has been a fellow of the Jerusalem Center for many years, before obviously my arrival to this institution, and brings the combination of being a professor of international law from the Hebrew University and practical experience as an advisor to Israel's foreign ministry, and one who's been involved in past negotiations. So I very much appreciate, Ruth, that you have come out tonight and you've prepared this important talk.
The subject that I would like to speak to, now I'm serious. First of all, I will start with 2 basic principles, which are the most important principles in this matter. Then we will see what do the Egyptians say, what do we hear. The article by Mr. Jonathan Dahuach Halevi, who wrote about a month ago a summary of what he has heard by members of the Islamic parties in Egypt. And also I rely a little bit on what I heard last Motzei Shabbat in the program on Ro'im Olam, where there was an interview with some of these Islamists, which was a little bit frightening. So this will be the first chapter. Then we will ask ourselves, what is actually written in the peace treaty? Because maybe you have forgotten, it was concluded in 1979 and you don't have to remember. Then we will see what are the rules of international law on the termination of treaties. What are the reasons which would justify the termination of a treaty bilaterally or unilaterally? 2 different questions. We also will see, I forgot to tell you, when I discuss the peace treaty, I will also look at the American engagements concerning the implementation of the peace treaty. We will see what are the provisions of the peace treaty which the Egyptians hate so much, and we will see what are the right ways to make any changes in the peace treaty if this is really what is necessary. So you see a lot of work. You will have to listen. I'm sorry, it's a little bit technical. So let us start with the 2 basic principles. If you fall asleep, that's okay, but remember these 2 principles. Principle number 1 is the continuity of states, which means a treaty made by Egypt was made by the state of Egypt, even though the government signed it. It was done by the government for the state of Egypt, because Egypt is the personality. It is the organ, it is the state which is responsible and not the government. Continuity, which means even if there is a change in government, whether it is according to the constitution or whether there has been a revolution, the state has to comply with the international treaties, its international commitments. The second principle, which is perhaps easier, you know it, pacta sunt servanda, I apologize that this is in Latin, which means treaties have to be implemented. You make an agreement, you have to implement it, full stop. So these are the 2 principles which I hope you will remember, even if you forget everything else. And now we will discuss the attitude of the Egyptian Islamist parties. First of all, and maybe people have not paid attention to it, when they speak about the peace treaty, they speak of the Camp David peace treaty. And this is already a lie, because the Camp David conference took place in 1978, and there 2 frameworks were signed by Israel and Egypt. One framework contained the basic principles, the basic principles for peace between Israel and Egypt. This is what we call peace preliminaries. But the final, full peace treaty was signed in 1979, which means a year later, almost a year later. And there is a big difference between the two. And I suspect that the Egyptians speak of the Camp David peace treaty because they want to forget a very important article which is in the peace treaty. And I think we have to thank Dr. Meir Rosen, who was at that time the legal advisor of the Ministry of Foreign Affairs, who insisted on the inclusion of this provision. It says in the peace treaty, 1979, that the parties have to implement their obligations under the peace treaty, even if they contradict other commitments, except for commitments under the Charter of the United Nations. And, which is even more important, they have to comply with the peace treaty irrespective of any other treaty. Why is this so important? Because at Camp David they signed two frameworks. One which is the preliminaries for peace between Israel and Egypt. The other one concerned the solution of the West Bank and the Gaza areas, the problem of the Palestinians. And if you look carefully at what the Egyptians said, according to the article that you just mentioned by Mr. Halevi, one of the arguments is that Israel has not fulfilled its obligations under the second Camp David text. They don't say second, they say Camp David. I must say the only person who says that the Egyptians have promised to fulfill and continue to fulfill the peace treaty is former President Mr. Carter. You can believe him if you wish. On the other hand, one of those people who were interviewed on Ro'im Olam said that even Carter has told him that Israel has not fulfilled its obligations. So who is telling the truth? Meister Kuckuck. I'm sorry, that wasn't German, which means God knows. So what is the attitude of the Egyptians? I just told you the problem that you don't see if you are not aware of the difference between the 1978 Camp David text and the peace treaty of 1979. Big difference. So they have, first of all, they say all the international treaties have to be re-examined according to three criteria. They say first principle is whether the treaty is in accordance with the Sharia law. Sharia, you know, is the Muslim law. Secondly, whether it is in conformity with the will of the people. And thirdly, whether the other party has fulfilled its obligations. These are the criteria according to which they want to study and re-examine every treaty that Egypt has concluded in the past. That, as I told you earlier, continuity of states. A state has to comply its obligations, even if there's been a change of government, but of course they don't mention that. They have not asked me, they have not been students in my class of international law. Secondly, they say that Israel and America are the worst enemies of Egypt. Full stop. They also say that we should disregard the economic advantages of the existence of this peace treaty. And there are several very important economic advantages for Egypt because of the existence of this agreement. What do they claim against Israel? Very, very vague. They say Israel has not complied with the provisions of the peace treaty. And what has Israel not done? They say that once Israeli army shot on Egyptian policemen or Egyptian army people in Rafah. It's true that this happened once, and Israel has apologized, etc., etc. Now they say there has been Israeli disregard of the treaty all over the years. And they also hint that Israel has not complied with the Camp David text concerning the Palestinians, which, as I said, is not part of the treaty. So you see that it's not so easy what they claim and what they say. They just don't like us, but what can we do? Now let's go back to the peace treaty itself. What does it say? It was, as I repeat, I'm sorry I repeat, but it's important. Camp David, and even in that article that I mentioned, he speaks of the Camp David Peace Treaty. It's not the Camp David Peace Treaty. Camp David was two frameworks which were signed in 1978. One, peace preliminaries with Egypt, only the general ideas, and the other one dealt with the solution of the Palestinian problem. The peace treaty was signed in 1979. It is this treaty which is the important text on which we have to rely. First of all, it says that there should be peace in the future. The peace was started with the conclusion of the peace treaty, and that the Israeli army and the Israeli civilians have to withdraw to the boundary which existed under the British mandate. Boundary under the British mandate. I mention it because in the peace treaty with Jordan, it is a little bit different. There they say on the basis of the mandatory boundary, and the boundary that exists now is different from that that existed under the British mandate. There should be they say normal and friendly relations between the parties. There should be economic and cultural cooperation. There should be full reciprocal recognition and preservation of the political independence and territorial integrity of each other. No acts of war, no acts and no threats of the use of force against each other. And here we have an interesting provision concerning the Sinai. And this is the provision which the Egyptians hate. It was agreed that the Sinai Peninsula should be partially, and I insist on the word partially, demilitarized. The word demilitarized is not used in the treaty. The word used, the expression used, is limitation of forces. The Sinai has been divided into three areas, A, B, C, with different limitation of forces, and in order to preserve the equality, Israel has also had to agree to a certain limitation of forces in a certain area which is in the south of the Negev, just north of Eilat. And this limitation of forces is, I wouldn't say controlled, but is monitored by the multinational force and observers. According to the peace treaty, this should be controlled by a force established by the Security Council, but this did not happen because the Soviet Union was against this peace treaty. Therefore, the Americans helped the Israelis and the Egyptians to establish an international force which is not related to the United Nations, what we call multinational force and observers. They, as I said, are not related to the United Nations, and they are funded by Egypt, Israel, and the United States. And so far they've done a good job because they don't speak a lot. If something, you see, they have to oversee certain things. First of all, the limitation of forces. Secondly, the freedom of passage through the Strait of Tiran and the Gulf of Aqaba. All this is the job of the multinational force and observers. And this is the main article that the Egyptians don't like. Then we have a provision on the settlement of disputes. Settlement of disputes between Israel and Egypt should be first by negotiations. If the negotiations don't succeed, you have to resort either to conciliation or to arbitration. This was the basis of the Taba arbitration, which took place between 86 and 88, which concerned the border in the Taba area. And I mentioned this article in particular because if a problem arises between Israel and Egypt concerning the continued existence of the peace treaty, the way to solve the problem is according to Article 7, which means negotiations, and negotiations fail, go to arbitration or to conciliation. There's also provision on the establishment of a claims commission, which should deal with financial claims. And, as I said earlier, there is an interesting provision which deals with the relationship between the peace treaty and other agreements. And as I said, this is not included in the Camp David text. This is only in the Peace Treaty of 1979. And here it is said that this agreement, this text, this treaty, should be implemented even if it is in contrast to another commitment of the parties, except commitments under the Charter of the United Nations. And in addition, it should be implemented irrespective of any other treaty that the parties may have signed, which means also irrespective of the Camp David framework concerning the Palestinians. I think these are the most important provisions of the peace treaty. What have I forgotten? Everything, never mind. Now, a few words about the commitments or the engagement of the United States. The United States has, first of all, its president has signed the peace treaty as a witness. Now, I always tell my students, if you have a wedding, you know that according to Jewish tradition, 2 witnesses have to sign the ketubah. But this does not mean that they have any obligation if the wedding does not function, if the wedding is dissolved. And the same applies, of course, also to some person who has signed a peace treaty of other parties. If you look at the Oslo Accords, which Gideon has just mentioned, I think about 5 or 6 foreign countries or institutions have signed it. The United Nations, the United States, the European Union. But if it fails, they are not to blame. So the United States has signed it as a witness. But in addition, there is an accompanying letter, a letter which accompanies the peace treaty, which was signed by the United States and given to the 2 parties, which deals with several matters and also with the question of what happens if something goes wrong. The United States has committed itself to consult with the parties. Consult, not more. And if necessary, if the United States thinks it is necessary, they may also resort to other means. But this is very vague. A similar provision has been included in a bilateral agreement between Israel and the United States, which was signed simultaneously with the peace treaty a few months later. So what we have here, those who think that the United States has given a guarantee for this peace treaty, they are wrong. The United States has only promised, and this is very nice that they have promised, that they will be able or will be willing to consult with the parties if the peace treaty gets into trouble. I'm sorry that I disappoint some of you. Now I think we will finish before 4 o'clock, don't worry. Now we come to a more difficult chapter, the chapter which deals with the question of how can a treaty be terminated according to international law. I will mention the various means, and with regard to those notions that might be relevant to the claims of the Egyptians, of course, I will mention it. First of all, it is generally, I'm here relying on the Vienna Convention of 1969 on the law of treaties. Most of the provisions of this treaty are of customary origin, which means that they are binding also for states who have not signed the Vienna Convention. Israel has not, by the way, for different reasons, not because of the contents, but because of the compulsory settlement of disputes. So the treaty first says that you can end the treaty, and now it is a little bit difficult, I'm sorry. You can end a treaty by common consent, of course. If the 2 parties agree to end the treaty, then it is ended. It can also be ended if they just conclude another treaty which replaces the former one. And this, for instance, happened in 1995 when Israel and the Palestinians signed the Israel-Palestinian interim agreement, etc., etc. This is the one with the 300 pages, by the way. Then they signed this treaty. It replaced, it substituted the agreement of Gaza and the Jericho area, which was signed in 1994. So here we have an example of a new agreement which replaces the old agreement by the two parties. Sometimes the treaty itself tells you how you can end it. Sometimes the treaty says it has to be done by common agreement, or you can even say that any party can terminate it with, usually you have to announce it in advance. But in the peace treaty between Israel and Egypt, there is no provision which gives the party, this or party or the other party, the right to terminate the treaty unilaterally. The only thing which we have, and this is important, not important but interesting, in Article 4, which deals with the security arrangements, including the limitation of forces in the Sinai, any of the two parties may ask for a revision of this provision, but any change has to be established by common consent. Full stop. Common consent. So here we have it even clearly said, if you want to change this provision, okay, let us talk, but it has to be changed only by common consent. So we have seen the situations where a treaty can be ended by common consent, either by consent or by concluding a later agreement which replaces the former one, or if the treaty has fulfilled its purposes, you just have done it. For instance, if you sell an island to another country, you have given him the island and he has given you the money, so the matter is settled. The treaty is ended even without any specific act of termination. The matter, of course, becomes much more, before that. How can you unilaterally end a treaty? And here we really get into trouble. First of all, there are treaties which by their nature may be ended unilaterally. For instance, treaties of a strategic alliance. Usually, and this is, I'm quoting from the book by Brierley, he thinks that this is the kind of treaty that the party may say not anymore, because this is, he thinks this is the kind of treaty which you can end unilaterally. Sometimes there is a dispute over the question whether the nature of the treaty is such that you can end it unilaterally. There was an interesting discussion concerning the Covenant on Civil and Political Rights of 1966. And the question was whether you can end it unilaterally. And the answer was no, it is not the kind of treaty which implies a right to withdraw from it. So the peace treaty with Egypt, of course, does not have any of these virtues, if you want to call it like that. It is not a treaty which, looking at it, you think that this is something which can be changed according to its own nature. It is not a military alliance, and it is not a treaty which by its nature may be terminated unilaterally. So what can be changed unilaterally? First of all, as I said, if the nature of the treaty is like that, or if the history of its conclusion shows that the parties intended it to be repudiated unilaterally. And now we come to the more difficult cases. First of all, and here we come to the part which is the most relevant to our case, if there is a material, and I underline the word material, breach of the treaty by one party, then the other party may terminate the treaty even though the other party has not terminated. There was an interesting case, for instance, when you know, the ship, what was the name of those ships that sank another ship in Australia because of environmental damage. What was the name of the ship? Yeah. And there was an agreement between France and New Zealand, not New Zealand, Australia, that the people who had done it should remain in jail in a certain island for 3 years. And after 2 years, France simply let them go. So this was considered to be a material breach which gave the other party the right to terminate the treaty. But I mention and I insist on the word material breach. What is a material breach according to the provisions of the treaty? A material breach is a breach which is a fundamental change of the obligations of the parties, and it is an essential element for the continued application of the treaty. So this is a very strict definition of what is a material breach. Material breach is also a case when you declare that you repudiate a treaty. This, of course, is a material breach, and the other party can say, go ahead, I've had enough of you. What is also interesting, you can never end a treaty because of a material breach if it is a treaty which deals with human rights. But in the case of the peace treaty, I don't think it's a question of human rights. So we have to ask ourselves, has Israel done anything which is a material breach which would give Egypt the right to terminate the treaty? I don't think so. There has been this case of the shooting in Rafah, but this was a single case. It was not, as these Islamists said, a continuing violation of the treaty. And of course, as I said, with regard to the Palestinians, first of all, we have implemented the autonomy. They got the autonomy not in 1979 or 80, but they got it in 1995, 93 and then 95. So we have implemented this agreement as well. But they try to insinuate that there have been material breaches for many, many years by Israel. And I think this is simply, I want to be polite, this is an error, misunderstanding, sounds even better. Error, misunderstanding, and you know what I mean. So we have seen the possibility that the Vienna Convention allows a party to repudiate a treaty if there has been a material breach by the other party. Of course, we can also ask ourselves the opposite question. If they have done such a thing, we can repudiate the treaty. If they have not if they have not fulfilled their obligations, we can say, Yalla udrup, we've had enough of it. Because it works both ways. Another matter which might be relevant, but so far has not yet been raised by them, is the treaty, the Vienna Convention allows a state to terminate or suspend or change a treaty if there has occurred a fundamental change of circumstances. Fundamental change of circumstances. But here we have to mention 3 important conditions. First of all, it must be a circumstance which was the basis for the conclusion of the treaty. And secondly, it must be a change which changes completely, radically, the obligations which you still have to fulfill according to the agreement. And in addition, it says, if the change of the circumstances comes from the party who claims the change of circumstances, he cannot rely on it. So you see here we have very, very important limitations. And we can add another one. No no treaty which establishes a border can be terminated on the basis of change of circumstances. And we know that the peace treaty has established a border between Israel and between Egypt. There was an interesting case, I think in 1997. I always have difficulties to pronounce the name, Gachipo or something. It's a Czech and Hungarian name. There was an agreement between Czechoslovakia and Hungary about the building of a dam on the Danube. And Hungary wanted to end it because of some fundamental change of circumstances. And the question was discussed by the International Court of Justice in The Hague. And the court mentioned all these limitations, all these conditions, and it did not accept the claim of fundamental change of circumstances, and it added that fundamental change of circumstances can be relied upon only if in very exceptional cases. But as I said, the Egyptians, as far as I have seen in those texts that I've mentioned to you, did not speak of fundamental change of circumstances. They spoke of violations by Israel of what they call the Camp David peace treaty. As I told you, Camp David treaty is a lie. It is not the Camp David treaty. Camp David was a framework of the main ideas for peace between Israel and Egypt, and an additional framework for peace in the Middle East. And the peace treaty between Israel and Egypt is the 1979 one. And I am sure that those Islamists in Egypt, who all the time speak of the Camp David agreement, know exactly the difference. But on purpose, they rely on this mistake because people have forgotten. People forget there's a difference between the Camp David Accords and the peace treaty. So we have seen the problems that I think I mentioned all of them. You didn't, you see, students usually ask questions in the middle, so it takes much longer time. But you don't ask questions. Either you sleep or you don't mind. So we have seen most of the, one other one, it is a supervening impossibility of performance, which means if you have promised to sell to the other state an island, and the island has disappeared, then you cannot give it to the other party. This is what they call supervening impossibility of performance. Again, Egypt has not disappeared and Israel has not disappeared, so I don't think that this is relevant to our problem. Now we have 3 additional questions which are much, much easier. Question number, maybe I should repeat what I said. It was so condensed. If you want to terminate a treaty, there are several means of terminating by common consent. It is either you make a new treaty or you agree to terminate the treaty, or perhaps it is written in the treaty itself that you have the right to terminate under certain circumstances. A unilateral withdrawal from a treaty, if it is not based on what is written in the treaty itself, can only be lawful if either the treaty is of such a nature like a military alliance that by definition or by its nature gives the possibility to withdraw, and we have never had such an agreement with Egypt. And secondly, if the treaty is of such a nature that it was the intention of the parties that it should be possible to terminate it unilaterally, all this does not apply in our case. Another matter which is important for our case, because of a material, and I insist on the word material, breach of the treaty by one party, gives the other party the right to end it. But a material breach is something very, very limited. It must be a breach of a basic provision which was the basis of the consent of the parties to agree on the treaty, and it must be such a change that it changes completely the fulfillment of the obligations of the parties in the future. And it does not apply to cases of human rights. Then we mentioned the possibility of withdrawing from a treaty because there was a fundamental change of circumstances. By the way, this notion of fundamental change of circumstances has created a lot of trouble in the past. Very often, I think the Nazis did it in several cases. They relied on fundamental change of circumstance in order to invalidate treaties, which of course nowadays is not possible anymore, because the Vienna Convention says that fundamental change of circumstances can justify the ending of a treaty only if the change concerns a circumstance which was the basis for the agreement of the parties, if this change could not have been foreseen when the treaty was signed, and if this change of the circumstances changes completely the obligations of the parties. And then we have seen the case of Hungary and Czechoslovakia, according to which only in very exceptional cases this claim of fundamental change of circumstances would be accepted. And we mentioned also the problem of intervening, I don't know which one it was, impossibility of performance, which of course in this situation does not exist. Now another question. Have there already been any changes in the peace treaty? Yes, but not officially. Because in the peace treaty it is said that the parties commit themselves not to conclude treaties which contravene the peace treaty. So the question arises, if it is a treaty between those parties themselves, is this also forbidden? The question was never asked in so clear terms, but practically there have been two minor changes. Change number one, when the multinational force and observers were established in 1981, because the Soviet Union did not allow the establishment of United Nations force, the composition of the force was somewhat different from the composition of the UN force, which was supposed to be established under the peace treaty. But nobody made any remarks about it. Only your humble servant, because she is a Ludwig. Second case, 2005, when Israel withdrew from the Gaza Strip. The problem was that since Egypt, according to the peace treaty, may not have around the borders more than a certain number of policemen and not even soldiers, the Egyptians said, if you leave the Gaza Strip and we have to be in control of the border between Egypt and the Gaza Strip, we cannot do it with such a small number of of policemen. And then there was signed an agreement which gave the Egyptians the right to put into this area more soldiers. No, not police, border police. Border police. And it's interesting, by the way, you see how international relations can work. Of course, I think that this is a change of the peace treaty. But it is said clearly in the text, it said, this is not a change of the peace treaty, full stop. But the Egyptians may bring here more soldiers, etc., etc. There are several such interesting cases of something which is not very logical, but it works. So we have had these two changes. Then another question that I want to mention. It's not yet 4 o'clock, but never mind. What are the provisions which the Egyptians really hate? I think the main provision is the one which limits their forces in the Sinai. And we have to think very carefully whether this is still very important for Israel, or whether we can be a little bit more subtle on this matter, whether we can give them the right to add more forces in the Sinai, because in the meantime we have found out that in the Sinai there are a lot of terrorists, and there are cases of Khatifa, how do you say Khatifa? Kidnapping in the Sinai. So it may be advantageous to allow the Egyptians to have some more forces in the Sinai, but I am not an expert on arms and certainly not an expert on the forces, so our people who are in charge of the bitachon, of security, they have to decide whether we can make any compromises on that. But how should this be done? There should be negotiations between Israel and Egypt saying, we agree that the peace treaty is valid, but we would like to ask for permission to change the provision of Article 4 and the annex which is included, namely that we agree that there should be a change in the situation of the limitation of forces in the Sinai. This is the right way to do it, by negotiations, and not by just saying, no, we don't want this treaty anymore. So this is more or less what I thought, and I would like, if you allow me, 2 additional remarks. First remark, I repeat what I said at the beginning. Remember continuity of states. If, chas v'chalila, we have a revolution now in Israel, Israel will also be committed to continue to fulfill its obligations under its international treaties. Change in government, even by revolution, does not change the international status of the state. Secondly, pacta sunt servanda. You have to comply with your international obligations. And if you remember these 2 principles from all this lecture, this would be enough for me.